Yes, because I'm trying to stay out of jail, trying to keep.
I know you're trying. Everybody is, but
I just want to be able to come back, so I can be able to maintain my job and get reassessed. The lady at community correction said I can get reassessed into a program, outpatient program, if need be.
In Washtenaw County, Michigan, what begins as a routine morning docket quickly turns into a series of high-stakes courtroom decisions. From a defendant already serving jail time in another city to bond violations, domestic violence allegations, and failed drug tests,
This isn't just another routine court calendar. Every defendant walking into this courtroom is carrying a different problem, but Judge Simpson has to answer the same question every single time. Can this person be trusted while their case is still pending? Watch closely, because today's decisions reveal exactly how judges balance fairness with public safety.
Simpson must decide who stays free and who is taken straight into custody. Every ruling could change someone's future.
court calls the cases of the people versus Matthew Fitzgerald. Two cases.
Absolutely. For the people of both matters.
Ready, Judge.
Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Fitzgerald.
Torshio Feaster, Assistant Public Defender, also on behalf of Mr. Fitzgerald, on file number ending 507.
Your Honor, Mr. Fitzgerald is not here. However,
Really?
there's a good reason for that,
Oh,
and I'd love to share that with you.
okay. Go ahead.
So Mr. Fitzgerald has a case in Livonia, and as you recall, due to a bond violation, you placed him in custody. During that time while he was in custody,
I
he had.
did.
Yeah, I'm just trying to make the record
That
clear.
you
Your-
sounded accusatory, but go.
No, I'm not accusing you of
No,
anything. Your Honor.
no, I get thick skin. Go ahead, Mr.
Well, while he was in custody, he was scheduled for his sentencing in Livonia, which he then missed. So they issued a warrant. He turned himself in on that warrant, and they did immediate sentencing, and he is currently in custody because they sentenced him to 10 days in jail. So that is why he is not here.
So, did you hear Elman's whole story? So Elman's whole story is, Judge, you tipped the first domino.
No, Your Honor.
That started this whole thing on the. Yes, that's exactly what you were saying. That's why Feaster is standing awake.
Well, Your Honor, he is in custody, and
Feaster
so
has
therefore
come
he's
nowhere
not
near the
here.
podium. Feaster like looking at you like, go ahead, you say it, man.
This is actually a perfect example of courtroom practicality. The defendant didn't skip court because he ran away, he missed it because he was already sitting in another jail serving a sentence. Instead of punishing him for circumstances already verified, the judge simply resets the case. Sometimes justice isn't about being harsh, it's about making the process work
Have I
logically.
mentioned how good it is to see you again, Your Honor?
Probably should have led with that. All right. So you're seeking an adjournment.
If the court would be so kind.
Well, Mr. Feaster, are you seeking an adjournment?
Yes, please.
Then that'll grant. All right. Probable cause conference on both of these cases, May 22nd, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Judge.
Thank you, Your Honor. 22nd.
Mr. Smart, Feaster said, I am not kidding. Court calls the case, People versus William Phillips.
And is it on behalf of the people?
Good afternoon again, Your Honor.
Oh, no, he's back.
Again, always great to see you. Robert Ellman with and on behalf of Mr. Phillips. Mr. Phillips, can you please state your name for the record?
William Phillips. Mr. Phillips is like, I'm not with him. No, go ahead. All right, what are we doing?
Your Honor, I was just appointed on this matter. I would be asking for an adjournment for time to get discovery. However, I'd also like to address bond whenever you would like to hear that from me.
Like to hear that. I'll adjourn this to May 22nd, 2025, 9 a.m. Yes, that's the bond, Mr. Earl.
Thank you, Your Honor. I would be requesting a change in the bond order to a no non-consensual contact. It's my understanding that the complaining witness in this matter has shared that request with the victim's advocate's office. And again, as you know, that would put the ball in her court as to whether to have contact with Mr. Phillips or not. So that's what we'd be requesting.
Okay.
I would also state that when did she do?
June 8th.
She's pregnant and due June 8th, and they do, how many other kids? Two?
Two.
They have two other children at home, so.
Your Honor, at this point, I would object. She did mention that to our victim advocate, and that wasn't our, however, I just have concerns given the facts in this case and that strangulation. I think it's something that should be addressed at a exam, or.
Notice what happened here. The defense explained why the family wanted contact restored, but Judge Simpson wasn't willing to rely on secondhand statements. When it comes to changing protective bond conditions, especially in allegations involving domestic violence, the court often wants to hear directly from the alleged victim before making that kind of decision. It's a reminder that safety concerns usually outweigh convenience.
Potentially in the future, but I don't believe it's appropriate to change that provision at this time.
And if I could just add, Your Honor, this is an older case. So they've been, to my knowledge, prior to the charges being filed, successfully cohabitating since the date of offense without any issues.
All right. I am disinclined to change that. I typically want to hear myself from anyone wishing to change the bond, even though they may communicate it. I then want to hear the people's sort of feelings on that, but I would need to hear from the individual themselves.
Thank you, Your Honor.
All right, so motion for bond reduction at this time is denied.
Thank you, Your Honor.
Thank you.
All right, you're all set.
Thanks.
And that's it for me, Your Honor. You don't have to deal with me anymore today.
Okay, so apparently on my face, it looked like I cared. No, okay. I'm sorry. I'm sorry. That was so wrong, Mr. Elman. Thank you, Mr. Elman. Always a pleasure, sir. I know that was. I feel bad now. What? Take it back. Court calls case People versus Jody Merritt.
People.
Or Yagi, Assistant Public Defender, apologies. With and on behalf of Ms. Merritt, Your Honor, may we approach in this matter?
Pardon?
May we approach in this matter?
Yes, you may.
Did you tell me that it was non-consumption, consumption? The people said non-consumption. It detected alcohol, but it was non-consumption. It was one of the things.
Go ahead.
Your Honor, I know I made arguments at the bench regarding my client's medical issues and her all of the things she's done to stay sober. Specifically within the last couple weeks, she's gone to AA meetings almost every day. She keeps a log. She has verified signatures. She set up an appointment for intensive outpatient. She, I know I said this at the bench, but just to reiterate for my client's benefit, she called down firms. They told her she was not eligible for inpatient. She has medical issues, which I won't go into detail on the record, but I did at the bench. And we were asking the court to consider continuing her bond.
Now the stakes get much higher. A SCRAM monitor isn't just tracking alcohol use, it also records possible tampering. Whether the defendant actually consumed alcohol or not, the court has to decide if the monitoring system can still be trusted. And once a judge loses confidence in compliance, bond can disappear very quickly.
And prior to the bond violation hearing, which we are requesting at this, we would request that it be set for a bond violation hearing.
In your Honor, as I indicated at the bench, previously we had accepted an offer. In this case, that offer at this time is revoked. The defendant does not have a current plea offer. It may be made again at a later time, but right now it has been revoked. The offer in front of you, I second the sobriety and recovery court. The issue here is that the SCRAM Tether does seem to confirm a 21-hour long tamper. with alcohol detected. So people have concerns for the general safety of the public, as this defendant is currently on bond for operating while intoxicated third offense with an alleged BAC of 0.17. I think it's 171 on the blood draw, and the risk that imparts to the public, if this is a person that is on the most restrictive bond condition we can impose for alcohol, other than incarceration, who has an alleged tamper with that SCRAM, there's too much to ignore, and I am requesting the defendant be remanded at this time.
Court, having listened to argument and having examined the alleged bond violation in this case, does find that it's significant with reference to the tamper to the device with alcohol detected. And for those reasons, and the court, on seeing it initially, issued a bench warrant with no bond. At this time, the court is going to order the defendant's bond is revoked. And I will set a bond violation hearing as well as a PCC for May 15, 2025 at 3 p.m. Defendant is remanded. Court calls the case People versus Stephen Watson.
And then on behalf of the people, Your Honor.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watson, Your Honor. Mr. Watson, state your name for the record.
Stephen Watson.
Go ahead.
Your Honor, I have had a chance to go over this matter with Mr. Watson. We're asking the court to set a preliminary examination.
All right. I will set a preliminary examination, but he has a bond violation in court.
Yes, we're aware of that, Judge.
All right.
Your Honor, I did receive the report and I have gone over it.
Does he have a prescription for that?
Your Honor, he did send I believe he tested positive last week. He did pay to have that sample sent to the for confirmation or not. They're waiting on that. Today is his day to test. Mr. Watson has indicated that he will that it will be negative.
For what?
Everything except for, I believe he has a medical marijuana card, Judge. I'd ask the court to allow him to run over there and test past this matter. And
Yeah, I haven't, since the end of March, I had cocaine, amphetamines, THC. Amphetamines, THC, and then that was on the 10th, and then on the 14th, I got cocaine again. I haven't.
This is where courtroom credibility becomes everything. The defendant insists he's working long hours and wants another chance to prove he's clean, while the court is looking at multiple positive test results and missed program requirements. Which matters more, today's promise or the pattern shown in the record? Let us know what you think in the comments.
Amphetamines then and THC into his system, but he's not reporting any medication that's going to show as an amphetamine.
Your Honor,
Yes.
also concerns that he missed intake on 4/28 as well.
Yes, I've been working 12 hours, 7 days a week. The community corrections lady told me to come to court, see if you allow me to come and drop. That way they can reassess me and get me back in. But if I drop today, I drop completely clean, everything. And, I'm trying not to lose my job. I've been at the same job for a year and a half. I've been staying out the way. I can go drop, come back, and everything will come back clean, Your Honor.
Yeah, he is working at Marsh Plating.
Is he saying that, does he want a hearing on this? I don't know what else.
Yes, because I'm trying to stay out of jail, trying to keep.
I know you're trying, well, everybody is, but
I just want to be able to go drop, come back, so I can be able to maintain my job and get reassessed. the lady at community corrections said I can get reassessed into a program, outpatient program, if need be.
Why is the amphetamine showing up in your system?
That part, I'm not sure. It could have been from some over-the-counter meds or anything, but I haven't used. I've been working every day. Like, that's all I do is work from 3 in the afternoon to 3 in the morning. I'm on my hours. I just asked the court to allow me to go drop to prove that.
You have all of the discovery, mister.
We do have the discovery, yes.
I just
People had their witnesses available the 13th.
We'll do our best, Your Honor.
So is he not admitting to this violation, but
Your Honor, in terms of the amphetamines, he is not admitting to them. In terms of the cocaine, I believe the initial test was.
One courtroom, 4 completely different outcomes. An adjournment, a denied bond modification, a revoked bond, and another defendant who earns a hearing instead of an immediate ruling. That's the reality of criminal court judges don't simply decide cases. They constantly evaluate risk, accountability, and whether each defendant has earned another opportunity before trial.
Positive for cocaine. There was a subsequent one. He did not have the funds. He was not working to the extent that he is now. He didn't have the funds to test it. I don't know if he wants to. You want to hear him?
no, that's okay. Well, I'll just we'll set his preliminary examination in person, May 13th, 2025, 9 a.m. That's before me.
If I could elaborate on bond, Judge.
Sure.
Your Honor, he is not a flight risk. He lives. He's residing over on East Forest, which is, probably 2 miles from here, in Ypsi. I don't think there's been any. Well, we're here on a violation, but there hasn't been any violation alleged contact wise or anything like that. He is gainfully employed. I'd ask the court to allow him an opportunity to test. He has indicated to me that they would, if the court would allow, they would welcome him in for another chance to interview for the community corrections outpatient program. But
if I did drop today, I would drop clean, no amphetamine, so that's sir.
I'll set a bond violation hearing at that same time. At the time of the preliminary examination, March 13, 2025, 9 a.m. At this point, defendant is remanded.
This courtroom session demonstrates how quickly very different cases can reach very different outcomes under the same judge. One defendant received an adjournment because he was already incarcerated elsewhere. Another failed to convince the court to modify a no-contact order. Another lost bond over an alleged alcohol monitoring violation. And the final defendant was granted a hearing rather than an immediate decision on disputed drug test results. In every case, the judge focused on one central issue: whether each defendant could be trusted to follow court orders while their criminal cases move forward. These hearings don't determine guilt. They determine how the justice system manages risk before trial. If you enjoy real courtroom proceedings and detailed legal breakdowns, be sure to like this video, share your perspective in the comments, and subscribe to the channel so you never miss another dramatic day inside the courtroom.